Good afternoon, everyone. Assalamualaikum warahmatullahi wabarakatuh. We are from Group 4. We would like to present our presentation today under the topic of judicial assistance that will be presented by me, Chairunnisa, and NATASYA AULIA. So let's get started. Now let's have a look at the first slide of judicial assistance for the arbitration. So even though we know that arbitration is a private institution and independent, but in fact, the court could intervene or play an important role to facilitate the arbitration proceeding. The court will give a judicial assistance. This judicial assistance from courts is needed in dealing with the arbitral procedure because of the fact that the courts have coercive power while arbitrations do not. Why do we need judicial assistance? So the execution of the arbitral award can be carried out voluntarily in common by the parties without having to involve the judiciary. But there are often the problem arises because of one of the party does not perform the award, so that in here the involvement of the court role is required. So to respond about this issue, Indonesia has ratified the New York Convention on 1958 concerning on the Convention on the Recognition and Enforcement of Foreign Arbitral Award through the Presidential Decree or Kepres number 34 of year 1981. Next, before we look further about this, now we'll have a look first at kinds of judicial assistances that will be delivered by the court for arbitration. They are, first, extent of judicial review, second, competence doctrine, third, anti-suit injunction, fourth, interim measures, fifth, cancellation of arbitral awards, and lastly, court assistance in obtaining the evidence. Now let's have a look first at the extent of judicial review. In the extent of judicial review, court may determine whether an arbitration agreement is valid or whether the arbitration agreement is null and void or it is inoperative or incapable to be performed. In here, the court will make a complete review or a prima facie review. Under the prima facie review, the court will refer the matter to arbitration if there was a reasonable likelihood that the party who brought the court action was in a breach of duty to arbitrate. This extent of judicial review is regulated under the Article 2, Number 3 of New York Convention that has been stated the justification of the court to review the validity of an arbitration agreement. Next is competence. This doctrine is related to the power of the court to give full or prima facie review of the validity of the arbitration agreement. This doctrine, just like the extent of judicial review. In fact, there are some various controversial of this doctrine that being practiced in many countries, for example, in France and in China. In France, this doctrine is recognized, so the court intervention is generally not allowed until after a final award has been rendered or has been out. Or the court can intervene to decide the validity of arbitral agreement only before the arbitral tribunal proceeding is begun. Meanwhile, in China, this doctrine is not recognized. So either the Arbitration Commission of the China or the People Court, they have power to rule the validity of the arbitration there. Next, we'll have a look at anti-suit injunction. This method is issued by court and arbitral tribunal to prevent an opposing party from commencing or continuing a proceeding in another jurisdiction or forum. In here, court have the power to issue anti-suit injunction in order, first, to enforce an arbitral agreement effectively, second, to protect the integrity of arbitral proceeding, and lastly, to restrain or to prevent parallel court proceeding. In some cases, the court also may issue anti-arbitration injunction when there is no agreement to arbitrate between the parties. Next, we'll have a look at interim measure. In some situations, the court may grant an interim measure only in clearly defined conditions, namely when there is a risk of serious violation might occur before or during the arbitration proceeding. Besides the court may grant this interim measure, the arbitral tribunal also have power to order interim measure. This interim measure is necessary in order to respect and to give appropriate security to the subject matter of the dispute, including to preserve the assets, maintaining the status quo pending resolution of disputes, and safeguarding the arbitral process. Now we'll have a look at the basis for interim measures. So the party who requests the interim measures must demonstrate to the tribunal that, first, if the relief or interim measures is not granted, the harm will be resulted, which is not adequately remedied by the money damages. Second, the requesting party has a reasonable possibility of succeeding on the merits of the claim. Next, we'll have a look at the power of court to revoke awards. Based on the Article 70 of arbitration law, it is explained that parties can apply application for certain arbitral awards to court under the certain conditions. Then the judge in here will make a legal consideration whether to grant or to reject such application.
And the next topic is court assistance in obtaining evidence. The first is procedural orders. So, procedural orders can be issued on many different topics and basically constitute the various decisions of the tribunal concerning the management of the arbitration process. So, such orders may concern scheduling or taking evidence or may delineate various obligations of the parties. As we know, procedural orders are not generally considered to be final, are subject to change by the tribunal, and may or may not be subject to enforcement by a court. Nonetheless, even when a tribunal has denominated its ruling as an order, a court may enforce it under the New York Convention if the court is persuaded that the ruling is in fact a final award. Seeking a procedural order from a tribunal concerning the taking of evidence is in some ways a last resort. From a practical standpoint, the first step a party should take in trying to obtain documents would be to simply ask a other party for the information. But if the other party does not cooperate, then a party could confer with both the other party and the tribunal could suggest to the other party that it should produce the information. But if this does not work, then a party may be able to persuade a tribunal to order the opposing party to produce documents or to produce witnesses under its control. And if the tribunal agrees, the party subject to the other has a strong incentive to comply with the order, since arbitrators can draw inference from any non-compliance. So, moreover, a party generally does not want a tribunal to think that it has reason to hide relevant information. Thus, compliance is usually Thus, compliance is usually forthcoming, and resort to the court to enforce such an order may not frequently occur. The second is national laws concerning court assistance. In Article 27, provides that the arbitral tribunal or a party with the approval of the arbitral tribunal may request from a competent court of the state assistance in taking evidence. So the court may execute the request within its competence and according to its rules on taking evidence. And also, it is clear the court can provide assistance within its own jurisdiction or within its competence. It is less clear whether it can provide assistance for requests for obtaining evidence from a foreign jurisdiction. A narrow reading of the language could view court assistance as only available in the jurisdiction where the request is made. So we can see in German and Swiss law. On the other hand, while not specifically referring to obtaining evidence outside of the jurisdictions, do not include language that would tend to limit the court reach. Thus, it appears possible in those countries that a court may assist with requests from a tribunal or a party regarding evidence or witness outside of the court jurisdictions. And then the third is summon issues by U.S. arbitrators. There are two areas of controversy concerning these provisions. The first, does the language of the provisions mean that an individual can be summoned and required to produce document only at the final hearing? Or can the documents be produced for inspection prior to the final hearing? There is a split in the circuit on these questions. This means that the law will be different in different federal circuits until the U.S. Supreme Court resolves the issue. And also, the language of Section 7 indicates that the arbitrators may summon someone to appear before them. The Second Circuit has held that this does not mean only at the final hearing on the merits. Rather, arbitrators can hold a hearing prior to the main hearing in order to retrieve this evidence. However, this ruling does not apply to a pretrial inspection of documents or deposition of a witness with no arbitrators present. And the Second Circuit's ruling only applies when the discovery is ordered to be produced at a preliminary hearing where the arbitrators are present. So the Sixth and Eighth Circuits have ruled that the arbitrator's powers include the power to compel production of documents either before or at its hearing. And the Third Circuit, on the other hand, has held that Article 7 of the FAA only requires a non-party to produce documents at a hearing on the merits and not before. In addition, the Fourth Circuit held that an arbitrator can only summon a third party for pre-hearing discovery if there is a showing of special hardship. In the Third and Fourth Circuits, therefore, there would be little, if any, ability to obtain documents or witness testimony prior to the hearing on the merits. And the second controversy concerned the geographic limitation on enforcement of an arbitral summons. Although an arbitrator has the authority to issue a summons to any persons, the right to enforce that summons is limited to the way a subpoena can be enforced in federal court. Under the Federal Rules of Civil Procedure, a subpoena can only be served with the jurisdiction where the request is made, or if outside the district, then within 100 miles of the place of the hearing or place of production of documents or depositions. And the fourth is tribunal in the United States seeking evidence outside the United States. So, if a tribunal state in the United States that evidence was needed from a third party in Spain. For example, could it obtain court assistance to compel production of this evidence under 28 U.S.C. in a litigated matter? A subpoena may be served abroad on a U.S. national or citizen or resident, but not on non-resident alien. It is not clear, however, whether these provisions will apply to an arbitral subpoena, the same issues that arise with respect to the enforcement of an arbitral subpoena outside the federal district in which the arbitrators are seated will appear to be pertinent here. And the last is court assistance in the United States to foreign tribunals. Although court assistance to arbitral tribunals in taking evidence is possible today in many jurisdictions, the court tends to have a great deal of discretion, which contributes to a lack of clarity with respect to how much help a court will actually provide. There is clearly resistance on the part of some courts to providing the same level of assistance in arbitration as they provide in litigation. So I would like to explain about the case of BTI and BTCO vs GIHD. In 1997, BTI and GIHD entered into 7 IDR or USD cross-currency swap transactions. It was set out in a ISDA Master Agreement on March 9, 1995. It has stated that the agreement is governed by English law, and if there any dispute happened, it would be resolved by arbitration under the rule of the London Court of International Arbitration, or LCIA. And on 16 January 1998, GIHD wrote to BTCO saying that they were not able to meet their debt because of their financial position. And on 27 January 1999, GIHD registered proceedings in Indonesia against BTI and BTCO. So in this agreement, they say that any dispute arising out of or in connection with this agreement or the breach hereof shall be referred to and finally resolved by arbitration under the rules of the London Court of International Arbitration, and which rules are deemed to be incorporated by reference into this clause. And the forum for arbitration under this paragraph shall be London, and the law governing the procedure for such arbitration shall be the law of England. And then the tribunal shall consist of 3 arbitrators, 2 of them shall be nominated by the respective parties. And on 2 March 1999, BTCO and BTI commenced an arbitration against GIHD in which they claimed the amount said to be due from GIHD of some US $89 million and a declaration that they were not liable to GIHD claimed in South Jakarta National Court.